As I mentioned, this webinar is intended to share some basics for anyone who may not know what's typically required in this type of scenario or when advocating for this type of child, and then to talk about some more specifics of what you can do or attempt to do, as the case may be. So first, what is a medically fragile child? You can also think of this as a child with special healthcare needs. So a student who has more complex health requirements or procedures that have to be implemented in the school setting, special therapies or specialized medical equipment or supplies. Any of those things that may be necessary to allow the child to participate during the school day, to be included in school, to benefit from the education that they're receiving. Most commonly, this is going to be a child who is eligible for special education under the OHI or other health impairment category. That's not an absolute, but oftentimes that is where disabilities or impairments would fall within the categories of eligibility under the IDEA. And there could be multiple eligibility categories, but I'm just highlighting OHI here, which is a chronic or acute health problem that results in IDEA eligibility when the condition causes the student to have limited strength, vitality, or alertness, and when those things adversely affect educational performance. So you need to have both. And you need to have you need to require special education, meaning instruction, and also related services. Important to note that you can't rely solely on a student's academic ability when determining need for specialized instruction, and that's true across the board. You should also consider factors like whether there are frequent absences, whether the student can access the general ed curriculum and how they need support accessing that curriculum. And here's an example of a case where a student had mental health issues, and the district had argued that the student had fine standardized test scores and did fine when she was in school, so therefore she wasn't eligible for special education. Well, the court in that case, which was in the Eighth Circuit, found that she should have been eligible for special education under those circumstances, even though she had performed well academically when she was in school. Now, mostly we'll be focusing on IDEA and children who have IEPs, but there is a comparable requirement under Section 504. So you can be eligible as a student who needs a 504 plan, but who may not need an IEP if you have a physical or mental impairment that substantially limits a major life activity. And that can be anything from walking, seeing, learning is one, a significant one. So and there goes my dog, apologize. In eligibility under Section 504 has to be considered without regard for the ameliorative effects of mitigating measures. So that means if a child takes medication or has medical supplies or equipment that helps reduce the impact of their impairment, they should still be considered eligible. And also an impairment that's episodic can qualify if it's still substantially limiting a major life activity when it's active. Oops. So then what may you be entitled to under the IDEA or Section 504? related services are a big piece of it, and particularly for medically fragile students, uh, related services include school health and nursing services. So school districts do have to provide the services that are necessary to maintain health and safety of a child in school. Uh, and some examples there: breathing, nutrition, other bodily function. So this can include nursing services, uh, urinary catheterization, suctioning for a tracheotomy, any services that can be provided by someone uh, who's been trained to provide it, as long as it's not a service that can only be provided by a licensed physician. So related services do not include things that only a licensed physician or medical doctor can do. But if it's something that a nurse can do, or even something that someone trained by a nurse can do, then it is a related service, and the school has to provide that if it's necessary for a student. So when we talk about health and nursing, uh, there are some variations or gray areas you might consider or run into. Uh, if there is nursing service that may be needed at any time, so as needed, then the school has to have coverage at all times. Otherwise, they could run into a situation where nursing is needed, but a nurse isn't available. And the school district can't rely on parents to provide a service that's necessary for students' health and safety. Um, there may be practical situations when that's the only option because staff aren't available. But even if a parent is, agreeable to fulfilling that role, uh, because there isn't anyone else available, that does not let the district off the hook from finding someone to perform that service who's not the parent. And a parent should always be clear that even if they're agreeing to provide a service in the moment, then they're not letting the district off the hook for that requirement. Medication, administration of medications, a related service if it's necessary to provide it during the school day. And that's not limited to the classroom or the school setting. If students need medication at a time when they would be on transportation, uh, or in the event of an emergency, then they may need to have a trained nurse or an aide, depending on what's being provided, accompany them on transportation. And that could be to and from school on a daily basis, that could be on field trips, anytime when the student might need to take their medication. Or if it's an emergency medication, then they may need to have someone on standby at all times. So assistive technology devices are any item, piece of equipment, or product, either commercially acquired or modified, customized, that's used to increase, maintain, or improve the functional capabilities of a child with disability. So that's the definition from the IDEA. It doesn't include medical devices that are surgically implanted, like cochlear implants, or maintenance or replacement of those devices. But the district is still required in those cases to monitor and maintain those devices if they're needed for the child in school. And again, same concept as before regarding nursing services or administration of medication. A school district can't rely on the parents to provide an assistive technology device. So if a child has, a stander that's required for them to be able to participate and move around the school, the school can't say, well, you have one at home, so we'll just use that one, and parents send it to school with your kid. and we'll just use that. The district has an obligation to provide their own assistive technology device for a student if it's required and in the IEP. If they don't do so, it could be a FAPE denial, and you'd have to consider what was the impact of the failure to provide that. Right? Was the child unable to attend school as a result? And if so, would you be looking at potential compensatory education to make up for the time that they missed? Medically fragile children may need alternative placements in the event that that placement in a regular school setting can't provide them with the support that they need. And this should be a conversation between the school and the parents. Parents should consider what their goals are for their child and what's appropriate for their child. Right. So if parents feel that inclusion and participation with gen ed peers is important, then they should approach this conversation with the district from that perspective of finding ways to ensure that the child can be included in school to the greatest extent possible. However, if a child's disabilities are severe enough that it is not practical or safe for them to be educated in a gen ed setting, they may need a more specialized program that is designed to work with children with their specific needs. Oops. Just a note at the bottom here that the district can't just say that they don't have necessary staff and therefore their placement's not appropriate, right? It's their obligation to hire necessary staff if the placement would otherwise be appropriate with those staff in place. And you can see here a case where that principle played out and the court found that the district had to provide some compensatory education for a period when they had no nurse on staff and the student was not able to attend school as a result of that. Homebound, you've likely heard this concept. This is instruction in the home or in another setting outside of school provided by the district if a child is unable to attend school for either 10 consecutive days or an ongoing intermittent basis that would add up to 10 days, be at least 2 days at a time, multiple times over the school year. And there's no minimum number of days that a child needs to be absent before they can qualify. What's needed for homebound is a medical doctor's certification. ISB has a form. So on the State Board of Education's website, there's a form that a medical doctor can fill out to certify a child for homebound or explain the need and the duration expected. The school can challenge that, but in most circumstances, if a medical doctor is saying that a child needs homebound instruction, the school district should agree to that. And the floor, the minimum of what's required for homebound instruction is 5 hours a week of tutoring. But the real question is what's necessary for the child to make appropriate progress towards their IEP goals? What is needed to allow them to work on those skills that are being targeted in the IEP goals and make progress on those. Schools very often default to the minimum 5 hours per week or 1 hour per day for each day of the school week, but you can argue for more than that. And you should also be thinking about how homebound services are provided. and whether it's in a way that your child can actually access their education from the home setting. So we know and we experienced during the pandemic that a lot of our kids and our clients performed poorly or were unable to actually access education remotely. It's not a conducive educational model for a lot of kids. And so if the school is only proposing remote instruction and you feel that your child can't access instruction that way, then you should say so and demand that they find another way to do it. Uh, the most common way would be to have a tutor come to the home or meet in another neutral location if that's feasible. Talking about placement, it's important to note that parents can always make placements of their own volition if they find a place, a school program that they think is appropriate for their child. They can pay for that placement on their own. Uh, that comes with financial risk at the outset, and also moving forward, the parents can seek reimbursement from the district, but the district can refuse, in which case there you would be at a place where you may need to file a complaint to pursue reimbursement if the district won't cooperate on that. In order to set yourself up to ensure that you can pursue reimbursement from the district, it's important to give notice to the district either in writing 10 days, 10 business days before placement starts, or at an IEP meeting prior to the placement. Notice that you are making placement at a specific program, that you feel that program is necessary to provide your child with an appropriate education, and requesting that the district reimburse you for that. So it's important to provide that in writing, ideally 10 business days before the placement, and that will essentially open the door for you to pursue reimbursement from the district if they deny the placement. Also, you should consider that having private providers provide in-home instruction or homebound services can be a unilateral placement. So if you feel like your child needs to be at home or can't access the school setting because of their disability, and the school district disagrees, you can let them know that you are providing private tutoring at home as a unilateral placement and ask them to provide it. And then if you do get into a legal dispute about whether the unilateral placement should be reimbursed by the district, the standard that you're operating under or that you need to persuade a hearing officer if you're in due process of is one, that the district's placement didn't provide an appropriate education, and two, that the unilateral placement that you placed your child in was appropriate to meet their needs. When considering a residential placement, if the school district is making the placement, the determination needs to be made that this is the least restrictive appropriate placement for the child. And sometimes school districts will default to a position that residential is not least restrictive because it's more restrictive than the general education setting. But the key, as with everything that we do and consider in terms of services, supports, placement for a child, the key is what's appropriate, right? So the question is this the least restrictive placement that's appropriate for the child? And the case may be that residential is necessary and is appropriate in certain circumstances. But again, to reiterate, if the parent unilaterally places, you just need to ask if the district's placement denied a FAPE and was the unilateral placement appropriate. Okay. It also has to be educationally necessary, right? So you're saying that the child can't access or benefit from an educational program without a residential placement. In the case of a medically fragile child, that may be because they need uh, consistent 24/7 supports and services to account for their disability. And we'll get into some slides here that describe recent changes to ISB rules to account for the fact that there's been a lack of appropriate ISB approved placements over the past few years. ISB approval is a process by which the State Board of Education uh, reviews a particular private school's credentials and curriculum and programming and determines whether it will be on the state's approved list or not. There are many schools that are not on the state's approved list for one reason or another, and that does not necessarily on its own indicate that it's not an appropriate placement. So there are programs that we've placed students in or assisted parents in getting placement in that are not ISB approved. And recently that's been more necessary because there have been less ISB approved placements available. And the state recognized this by creating new rules to allow for one time or on a case by case basis approval of placements in not otherwise approved ISB schools or private schools. And the reason why that's important is the school district cannot place a child in a non-public special education program that isn't ISB approved, except for under these new exceptions. So school district would be very reluctant or refusing to make a placement in a non-approved school if there was not this rule in place to allow them to do so. So as you see here, a school district may place in a non-public special facility that's not approved by the State Board of Education under certain circumstances. The school district has to submit an application to the state laying out these details, that the facility has appropriate certification, age appropriate curriculum, they demonstrate their enrollment and attendance data and indicate the ability to implement the child's IEP. And also the school district has to show that they made good faith efforts to find an approved facility, but no approved facility is available for the student. We can skip over a few of these here. Also important to note that a hearing officer can order placement in a non-approved program if you go through a due process hearing and advocate for that placement. So in this case, ISB is not approving it through an application, but the hearing officer can say, this is the placement that the student needs. So demonstrating the need for a non-approved school, it's easier if it's a unilateral placement, right? Because then all you need to show is that the school district's options were not appropriate and that the placement that you're going for is appropriate. But if you're seeking this placement prospectively, you're going to need to prove that it's appropriate to meet the child's unique needs. The other schools were not appropriate or available, that the school utilizes the IEP process or something similar and has appropriately trained staff. It's key in preparation for an IEP meeting if you believe that an alternative placement is necessary, to identify that school in advance, uh, make sure that the parents are on board with that program, seek admission ahead of time if possible, so you can present the most, you know, to make the best case to the school district by saying, "Hey, we've got an admission. We know that the school will accept the child, and we want you to agree to that placement." Um, some schools or programs won't consider or provide much information to parents without a referral from a school district. Uh, you could still ask them to share hypothetical information to sort of verify that the type of student being described would be appropriate, and also find out if they have immediate availability. And then again, if the school is not ISB approved, uh, you want to find out as much as you can about these things that are related to the program. There's also an ISB approve or a website through ISB where you can search for ISB approval and see what programs are or aren't approved by the state. And then you also want to make sure that you're documenting that you have a search for approved facilities and essentially exhausted those options and found that none are available if you're going for a non-ISB approved placement. So that is the very quick explanation of those things, and we've got time here, and we've got a very small group, so I'd like to turn it over to you if you have any specific questions, or if you came to this presentation looking for answers to particular questions or problems that you're facing. Um, happy to talk more specifically about any cases that you're dealing with.
This is Mel from Laurie Children's. I do work inpatient psychiatry, working with a vast population from intellectual disability, kids living with autism, to all the way, depression, anxiety, kind of like the full gamut. But and I always refer families with Matt Cohen and his team if they need further educational advocacy support. But just in case, if a school has not approved residential at this moment, just because they're doing good in the school, but at home they're having difficulty, then they receive the FSP grant. Funds are going to cover. Does school eventually have to pay for their end, or does PUNS cover everything if the school has not approved it?
So I know with FSP, if a child is approved for residential placement through the FSP program, then the school district is required to pay for the tuition component of the placement, and the state agency pays for the residential or room and board part of it. So even if the school has not found the child needing residential placement, if it's approved by FSP, then the school district is obligated to pay for that portion of it.
Okay, so the schools would eventually be responsible for their portion.
Right.
Okay, thank you so much.
Sure. Any other questions, comments?
This is Mel again.
Go ahead. Yeah.
I would say for the past, especially this year, a lot of schools, whether we're advocating for increased school social work supports, paraprofessionals, residential therapeutic school, anything, I am always hearing there's not enough staff. I mean, it's constant. And I always kind of remind the school, yes, there's short staff everywhere, but this is what the child needs at this moment. What are your recommendations working with schools and districts if they are constantly bringing that up? And it's not just them kind of venting or sharing that we're in a staff shortage crisis, just kind of like there's nobody there. And then I'm advocating for my patient, my family, saying, well, this is the supports that this child needs. What kind of approach do you utilize? I mean, it's friendly reminder, this is what the child needs. It's, it is a team decision. We all have to agree upon it, but I'm kind of, this year, I feel like that's just what they're always kind of using as an excuse. So any advice there of what verbiage or lingo I can use?
Yeah, well, at first, there's sort of two ways that could go, right? One would be if they're responding that they're not going to write that into the IEP because they don't have staff, uh, in which case that's totally wrong and not what they should be doing, right? The question is what's necessary first, and then figure out what staff is available. You don't justify finding a child ineligible for a certain service or not putting it in an IEP because you don't have staff. That's that would violate the child's rights. So if that's happening, then you need to indicate that the school district is not making an individualized determination based on the student's needs. They're making a decision based on lack of staffing. Now, if the school is acknowledging the child's needs and writing those services into the IEP, but then saying we can't implement that portion of the IEP because we don't have staff. We're searching for staff, but no one's filling the position. That's a real thing that's happening. Like you said, there is a shortage in a lot of areas of available staff. That doesn't excuse the obligation to provide staff, but it can create a scenario where there's no option. So under those circumstances, one thing that a parent could do is try and find staff on their own, see if there's any private providers that they have or work with who could provide that service either in school or out of school. If it's something where a child needs the service to be in school and therefore without it they can't go to school, then you could talk about looking at alternative placements that have that staff built in. So that may be a reason why a child needs an alternative placement in a separate program. If it's the worst case where there is no alternative program and the school can't provide the service and the kid is stuck at home as a result, or even if they are, depending on the circumstances, still able to go to school but aren't accessing their education in the way that they would be with the support of a nurse or whatever service isn't being provided, then you should start thinking about compensatory education and figuring what was the impact of the missed service on the child's skill development or acquisition of certain skills, and potentially seeking additional instruction or related services over the summer or after school hours to make up for that once the situation with the staff has been resolved.
Thank you. Appreciate it.
Okay. To last call for questions.
Hi, Brad. This is Anne Marie.
Hi,
How you doing today?
I'm good. How are you?
Good. So, I did find a lot of the information that you shared to be not only reinforcing of, I think, a current situation that we're both familiar with, but one of the questions that I have then is, what is an appropriate time frame when a child has been unilaterally placed and the district has not responded in support of that to pursue that compensatory reimbursement for the services that the parent has had to secure for that homebound unilateral placement?
Well, there's no set amount of time. I think in the circumstance that you're describing, the parents are self-funding services and want to seek reimbursement from the district. They can pursue that at any time.
Okay.
There's no set amount that you need to sort of build up to before you pursue reimbursement. I guess there could be some practical consideration in terms of, you know, if you need to go forward with a due process hearing to try and compel the district to either settle with you or go through the hearing and be ordered to pay to reimburse, you want to make sure probably that that the family has incurred enough, that there's been significant enough financial impact that pursuing that through a hearing, how do I say this, that the costs of pursuing that through a hearing wouldn't outweigh what they stand to gain
Right.
through what they've paid.
Sure. But certainly, like, they could pursue making that request at any point in time, and based off of the response by the district, obviously if they're in favor of it, great, and they're willing to support it, that kind of ends the initial conflict. But if the district is still unwilling to support that reimbursement, that they could move forward with challenging the district on that then.
Yes, that's right.
But again, looking at the cost analysis of pursuing that.
Right.
Versus the money that's been paid out.
Yes.
Okay. Thank you.
Thanks, Anne. Anyone else? Well, I will say, of course, if you have any other questions right now, feel free to ask them. If not, but you get off the Zoom here and a question comes to you later and you say, oh, geez, I should have asked this, feel free to email me. My email is brad@mattcohenassociates.com, and I'd be happy to chat with any of you about questions that come up or pop into your mind later if there are any.
Just a quick question from Anne Marie. Will you guys be hosting any more of the webinars this summer? And tied to that would be, do you know what the topics might be yet?
I do believe we will be hosting other webinars. I don't know the exact schedule, but I think that that's something that we would post on our website or in our newsletter coming up once we know what that is.
Okay.
And if I hear of anything, I can also try and give you an update, Anne Marie.
Okay, wonderful. Thank you.
Sure. And you know that all of our previous webinars are available in a library on our website. So you
Oh,
can-
is it through the website or on Facebook?
through our website, in our
Okay,
resources tab, you can access old webinars.
okay,
Yeah.
thanks. I
But,
actually
but yeah.
did not know that.
Oh, okay. Well, there you go. And keep an eye on Facebook as well. That is where we would be posting
Okay,
as well.
yeah, that's where I've seen them pop up, but I did not realize that you could access them on the website, so I appreciate that.
Yeah, take a look.
All right, great. Well, thank you so much and have a great day.
You too, man. And thanks everyone else for coming. And goodbye.
Thank you. Have a great day.
Take care.